Hello again. I'm Professor John Blakeman from the UW-Stevens Point Political Science Department, and I'd like to welcome you back to my ongoing lecture series on the U.S. Constitution, sponsored by the UW-Stevens Point Alumni Association and their Alumni College Experience. So remember in the prior lectures, we focused on congressional power, and we looked at several cases concerning the powers of Congress and how the Supreme Court has interpreted those powers over time. In lectures 10, 11, and 12, we are going to shift our focus to the presidency, and we will look at some key cases concerning the powers of the presidency, especially in times of national crisis. So, lecture number 10, Ex parte Merryman. Can the president, during the Civil War, order the seizure and detention of Confederate sympathizers without trial? Lecture number 11, also coming out of the Civil War, can the president order the seizure of ships trying to supply the Confederacy? And then lecture number 12, coming in the 20th century during the Korean conflict, can the president order the seizure of the entire steel industry of the United States? All of these cases force us to confront very significant questions about the constitutional powers of the president during times of national crisis. So we'll start with Ex parte Merryman with lecture number 10. Remember that Article 2 of the Constitution deals with the powers of the executive branch, but it's written in fairly vague terms. It doesn't give us a lot of detail about what the president's powers actually are. So it does tell us, for example, that the president is the commander-in-chief of the military, that the president negotiates treaties, and that the president makes top-level government appointments and judicial appointments. And then the Article 2 also has what's called the Take Care Clause, that the president has the constitutional obligation to take care that all laws be executed. So, in terms of the president's actual powers in our constitutional system, Article 2 is fairly vague. It's not like Article 1, Section 8 of the Constitution, which gives us that long, detailed list of congressional power. And remember, with Article 1, Section 8, congressional power, we also have Article 1, Section 9, which prohibits Congress from doing certain things. We don't have that in Article 2. It's simply not structured the same way. Now, why that is, well, a lot of different arguments for it. Probably the most compelling one is the framers of the Constitution. They figured that the executive branch would be, of course, an independent, separate branch from Congress, the legislature, but it would also be somewhat controlled by it. And I use that word carefully because there's no question that the framers wanted an independent executive. But remember, they put in place checks and balances. So, for example, with the president's treaty power, the president negotiates treaties, but he then has to get the approval of the Senate. Or with appointments, almost all presidential appointments have to be approved by the Senate, federal judges and high-level cabinet appointees. And then the Take Care Clause. What that means is the president executes the laws passed by Congress. And so even though they intended for the president to be an independent office, they thought the president might also be sort of second fiddle to Congress, that the Congress would be the most prominent or important branch of the national government. That's one argument. Another argument, and we'll talk about Alexander Hamilton in just a second, because he's the one who gives us this approach, is that Article 2 is intentionally vague, so the powers of the presidency can be somewhat flexible. Now, Alexander Hamilton, he wrote Federalist Paper number 70, among other Federalist Papers. And if you recall, the Federalist Papers were written after the Constitution is signed and sent out to the states for ratification. Federalist Papers were written 1787 and 1788 by Alexander Hamilton, James Madison, and John Jay. And it was Alexander Hamilton who devoted the most attention to the powers of this proposed executive branch, the presidency, in Article 2. And all we really need to focus on right now is his argument, as he put it, that that the executive must have energy, what we call his energetic executive argument, that the powers of the presidency must sort of rise and fall as the nation encounters crises, for example. And the powers of the presidency should be somewhat flexible, and the president should be an energetic office with the power necessary to do what is required. Other Federalists thought the same way. So, for example, John Marshall, yep, he's the same guy, Chief Justice John Marshall in 1803 with Marbury versus Madison. Back in 1799, he's a member of the House of Representatives from the state of Virginia. And the House and the Senate are debating a treaty with Great Britain. And Marshall argues that the president, when it comes to the treaty power, the president is the sole organ of foreign affairs, that the president is the one branch of government that represents the United States to foreign countries, to the rest of the world, and therefore the presidency has this inherent power to conduct foreign affairs and international relations. We encounter John Marshall's argument in the late 1790s, and that argument comes back time and again in over 200 years of our constitutional history. That when it comes at least to foreign affairs and international relations, the president speaks for the nation, and the president is the most powerful institution in our constitutional system when it comes time to engage in foreign relations or foreign affairs. And that gets us to thinking about presidential power. The powers of the president are enumerated in Article 2, just like the powers of Congress are enumerated in Article 1, Section 8. But we also recognize that the president has inherent power, power that is not written down, and power that stems from sovereignty and nationhood of the United States. And inherent power would be a little different than the implied power that Congress has in the necessary and proper clause. With implied power, the argument is the power is not written down, but it's linked to another power that is spelled out. With inherent power, here the argument is it's power that simply inheres from the fact that the United States is a sovereign nation in a global system of international relations. So this gets us thinking about inherent power and when it becomes prominent. It becomes prominent usually during times of national crisis. And it's in those kinds of cases where courts, especially the Supreme Court, really have to sort out what the limits on presidential power are. So let's go to the Civil War. And this is where we really start to encounter our first debates over presidential power and the Constitution. And there are two cases that I will focus on coming out of the Civil War. The first one is called Ex parte Merryman, and the second one is called the Prize cases. There are a lot of other constitutional disputes that come out of the Civil War concerning presidential power. These two are sort of representative, I think. So to put them in their historical context, Abraham Lincoln is elected president. Among other things, that prompts Southern states to start to secede in spring of 1861. As states are seceding, leaving the Union, Congress is out of session. And remember, back then, it was very, very difficult to bring Congress back into session. Members of Congress might often have to travel weeks in order to get to the nation's capital to represent their districts and their states. Abraham Lincoln has several problems on his hands. First off, states are seceding. The Union is disintegrating in front of him. South Carolina fires shots on Fort Sumter, which effectively starts the Civil War. Other southern states indicate that they are going to wage an aggressive campaign against the Union. And ultimately, Abraham Lincoln, President Lincoln, his first requirement, as he sees it, is to reinforce the nation's capital, to protect the nation's capital at all costs. And respond to the rebellion. And so in terms of reinforcing Washington, D.C., and if you think about your Civil War history, you'll recall that by 1862, the Confederate capital is in Richmond, Virginia. And in this day and age, Richmond and Washington, D.C. are about a 2 hours drive by interstate from each other. Back then, maybe a one, or I honestly don't know, a 2-day horseback ride, perhaps. That's pretty close. And so when the Confederacy's knocking on the front door of the nation's capital, President Lincoln is quite naturally going to be somewhat concerned about that. So he does 3 things. First off, he orders the reinforcement of Washington, D.C. He orders troops be brought down from Pennsylvania and New York to reinforce the nation's capital. And he runs into a problem there, because it turns out that most of those troops have to pass through the state of Maryland, which, if you recall from your history, Maryland is a border state. And it's not exactly clear in 1861 if Maryland will secede or not. It doesn't, but it's not quite clear in the spring of 1861. And it turns out there are a lot of Confederate sympathizers in the state of Maryland, and they will come out and literally block the one train track that runs from Baltimore to the nation's capital, and they will prevent troop trains from getting through. To counteract that, Lincoln suspends the writ of habeas corpus, and he orders the U.S. military to step in and arrest any Confederate sympathizer, anyone in Maryland engaged in anti-Union activities, and to hold them indefinitely. That gets us through the case ex parte versus Merriman. Another thing Lincoln does, number 2, is he orders a blockade of southern ports. He orders the Federal Navy to blockade southern ports so that no shipping can get into those ports and no shipping can come out of those ports. Now, of course, the blockade is not 100% foolproof. Ships do get in and out, but the Southern blockade from 1861 up through 1864, well, into the end of the Civil War in 1865, does help economically cripple the South. It's vital. But it turns out the Federal Navy is seizing and destroying and owning several ships that are registered in other countries. And those ship owners turn around and they sue the United States government in our own court system to either get their ships back or to get compensation for their destruction. Those are called the prize cases. And there were a lot of prize cases that come up during the Civil War. And then finally, a third thing that Lincoln does that really raises constitutional questions, he imposes the use of military tribunals on certain states that he considers have a high number of Confederate sympathizers in them. One example, the state of Indiana. And so people in Indiana could be arrested by the U.S. Army, tried for seditious activities by the military in front of military judges, and then imprisoned by the military or even executed. Now, we don't deal with the military tribunal cases, but after the Civil War is over in 1867, the Supreme Court rules that Lincoln's use of military tribunals to try civilians in parts of the Union where law and order was still intact. Lincoln violated the Constitution, according to the Supreme Court. We are going to take a look at the first 2 cases, though, ex parte Merriman and the prize cases. Now, before that, to my class here at Stevens Point, I always like to display this map of Washington, D.C. during the Civil War from 1861 to 1865. It shows all of the many forts that the federal government built to defend the city. It shows you the one train track right there that comes from Baltimore into the city. That is the only train track into Washington, D.C. There are the toll roads, the pikes that they're called, which are back then, relatively good roads for moving goods and people. But it's the train that is really, really important. And the train track passes through what Lincoln considers to be somewhat hostile territory in the state of Maryland. But the sheer number of forts and defensive installations that are in Washington, D.C. during the Civil War sort of indicates that the city itself was often at fear of being under siege because it was right on the doorstep of the Confederacy. So let's take a look at those two cases, and I'll introduce the two cases, Ex parte Merryman and then the Price cases, and then in this lecture I will work you through the Ex parte Merryman case. In a separate lecture we will talk about the Price cases. But Ex parte Merryman, 1861, the simple question is, can President Lincoln suspend habeas corpus? So first off, what is habeas corpus? Well, it's an old common law right, a legal writ, as it's called, or an order, you think about it like that, a writ or an order from a court to the government. And what the order does, what the writ does, is a judge orders the government to justify why it is detaining a specific individual. And habeas corpus literally means produce the body. And the way the common law writ worked is if a judge granted the writ of habeas corpus, the government had to bring the person into the courtroom and justify to the judge why the person was being deprived of his or her liberty. Now, the government might have a perfectly valid reason to detain someone. And if that reason can be explained to the judge and it's acceptable legally, lawfully, then the person continues to be detained. The government might not have a lawful reason, and in which case the judge orders the government to let the person go. So it's not necessarily about guilt or innocence. The question is, does the government have a lawful reason to detain this person? Now, we encounter the writ of habeas corpus, as we will see, in the Constitution, in Article 1, Section 9. Remember, Article 1, Section 9, those are the prohibitions on congressional power, the things Congress cannot do. And Article 1, Section 9 is pretty clear. It says, Congress cannot suspend habeas corpus except in times of war or rebellion or when the public safety requires it. And so that gets us thinking about the constitutional question right away. Habeas corpus is mentioned in the section on congressional power, meaning Congress has the authority to suspend habeas corpus, but only under very limited circumstances. But we're not quite sure about the president. Now, we do know that Lincoln is acting in a time of crisis. And he, as he sees it, he must take extreme measures to protect the Union. So we'll encounter that question in a few minutes. So, Mr. Merryman, he is from Maryland. He's a Confederate sympathizer. He is arrested in the middle of the night in his home by the U.S. military. He's taken to Fort McHenry, where he is imprisoned. He's accused of being a Confederate sympathizer, a traitor, among other things, but he isn't tried. He is not convicted. He is just being detained, imprisoned by the national government. And so he contests his detention by the U.S. Army. And the court is not concerned with his guilt or innocence just yet. That's not the question. The question is not, is Mr. Merryman a treasonous person? He's not been tried and convicted of anything. The question is only, can he be lawfully detained by the government? Okay, then we've got the prize cases. Can President Lincoln order the U.S. Navy to blockade southern ports? And can naval ships seize other ships trying to run the blockade? The Constitution is absolutely silent on whether the president can order the Navy to blockade southern ports that are part of the United States or states in rebellion. So the Constitution is silent about that. And it's also the seizure of property by the national government as well. The Constitution, well, under the Fifth Amendment, does point us in a certain direction. Okay, so let me get the Ex parte Merryman case up. Now, with Ex parte Merryman, this case is sort of interesting for several different reasons. I should say, other than the habeas corpus question. We encounter a Chief Justice of the United States, Roger B. Taney. And Taney has been on the Supreme Court, oh gosh, since the 1840s. I think that's right. But most importantly, for our purposes, 1857, he was the author of the Dred Scott opinion, Dred Scott versus Sanford, which, if you know your constitutional history, that's the infamous Supreme Court case where the court says that African Americans, slaves, and freed slaves are not citizens of the United States. And in that case, Dred Scott could not sue in the federal court system to assert his freedom from slavery because he was not a citizen. And there's a lot of language in Dred Scott as well, where Chief Justice Taney points out that slaves, African Americans, even freed slaves at the time of the drafting of the Constitution, 1787, they were not meant to be part of the United States. They were not to be considered citizens of the United States. You know, and Dred Scott is a black mark, to be sure, on the Supreme Court's history. No question about that. It's a pernicious, harmful opinion. It's horribly wrong. It has been overturned. In the 1860 presidential election, President Lincoln was very, very critical of Chief Justice Taney and the Dred Scott decision. And Lincoln argued how wrong the Dred Scott case was. So by the time we get to 1861, let's just say that Taney and Lincoln are very distrustful of each other. And Lincoln is especially distrustful of Chief Justice Taney. Now, there's one other thing about this case that's sort of interesting. When Congress set up the federal court system in 1789, Congress created federal district courts, which are the trial courts in the system, and there would be at least one federal trial court in every state. Congress then grouped states into geographical regions called circuits. And you would start your case in a federal trial court, you would appeal to a circuit court, and then if you wanted to appeal one more time, you could go to the U.S. Supreme Court. The circuit courts are what we call intermediate appellate courts. They exist between the U.S. Supreme Court at the top and federal trial courts at the bottom. Now, in 1789, and this continues on to this very day, every Supreme Court justice is also in charge of a federal circuit. And it used to be from 1789 all the way into the late 1890s that each Supreme Court justice during the summer, when the Supreme Court was out of session, each Supreme Court justice would travel out to his circuit and act as a lower appellate circuit judge. And then justices will travel back to the United States Supreme Court in the nation's capital and resume their duties as justices. So, the way this case comes up, Mr. Merryman is imprisoned in Fort McHenry outside of Baltimore. His lawyer files a writ of habeas corpus with the federal court system. But his lawyer knows that he can go directly to the federal circuit court in Maryland, located in Baltimore, And his lawyer also knows that the head of that circuit court is none other than Chief Justice Roger Taney, the Chief Justice of the United States. And so his lawyer files the writ of habeas corpus directly with Chief Justice Roger Taney, serving as a circuit judge, not as a Supreme Court justice, or Chief Justice of the United States, I should say. And so, in a sense, this isn't really a Supreme Court case, but it is a case decided by the Chief Justice of the United States, acting in his capacity as a federal circuit judge. So it has that interesting context to it. Now, Roger Taney gets a hold of the writ of habeas corpus. And, it's fair to say Taney is just entirely skeptical out of all of this. And in the opinion, of course, Taney gives us a very good factual summary. He does so at least twice, actually, about the arrest of Mr. Merriman and his imprisonment, so on and so forth. But here, upon this petition, the writ of habeas corpus, the Chief Justice passed the following order. In the matter of the petition of John Merriman for a writ of habeas corpus, ordered that the writ of habeas corpus issue and that it be directed to General Cadwalader, who oversees Fort McHenry, and be issued in the usual form by the clerk of the circuit court in the United States. And so what Taney is doing is he's, in a sense, granting the writ. He's ordering the U.S. Army to bring Merriman into his courtroom so that he can force the U.S. government to justify Merriman's detention, and he can determine the lawfulness of it. And if you read through the factual summary that Taney gives us, you read that the U.S. Marshal, acting out of the circuit court, served the writ on General Cadwalader. So at least the U.S. Army has been given Chief Justice Taney's order. Cadwalader doesn't show up, and he does not produce Merriman in Taney's courtroom. He sends a lower-ranking military officer with Cadwalader's response. Now, this is sort of unusual. It seems to me when the Chief Justice of the United States commands you to show up in his courtroom, you probably would. But General Cadwalader's response is simply this right here. The prisoner was brought to Fort McHenry. He's charged with various acts of treason. It can be clearly established that the prisoner has made often and unreserved declarations of his association with this organized force, the Confederacy, as being in avowed hostility to the government, and in readiness to cooperate with those engaged in the present rebellion. That according to the U.S. military, according to General Cadwalader, Merriman has made clear his intentions. He will join the rebellion. He will be part of the Confederacy. And Cadwalader says it can be clearly established that Merriman has done this. Furthermore, Cadwalader says, he is duly authorized by the President of the United States to suspend the writ of habeas corpus for the public safety. This is a high and delicate trust enjoined upon him by the President, and he is instructed that in times of civil strife, errors should be on the side of the safety of the country. So Cadwalader not only refuses to bring Merriman into Taney's courtroom, Cadwalader says, well, it can be established that Merriman is part of the rebellion and he's seditious. And I have also been authorized by President Lincoln to suspend the writ of habeas corpus for the public safety. And I should err on the side of safety if any questions arise. So it's a bit, Cadwalader is basically saying, I'm not coming into your courtroom with a prisoner. I have enough information to detain the prisoner on my own, and the President has told me to do this. And Cadwallader respectfully requests that you postpone further action upon this case until he receives further instructions from the president. Now, it seems to me the Chief Justice ought to be somewhat indignant about this. I mean, if you think about it, this is it sets up a direct conflict between the executive branch and the judicial branch. And the executive branch and the U.S. military are directly ignoring an order of a federal judge. And not just a federal judge, but the nation's highest judge, the Chief Justice of the United States. So Taney is probably quite angry about all of this. His anger doesn't necessarily come through in his opinion, perhaps. But he finally gets to the heart of the case. He says the detention of the prisoner was unlawful upon the grounds, one, that the president, under the Constitution of the United States, cannot suspend the privilege of the writ of habeas corpus, nor authorize the military to do it. And number two, a military officer has no right to arrest and detain a person not subject to the rules and articles of war for an offense against the laws of the United States, except in aid of the judicial authority. So first off, the president has no authority to suspend habeas corpus, and the military does not either. And the military has no authority to arrest a person who does not fall under the articles of war, who falls under U.S. law. A military officer cannot arrest someone under U.S. law, except when they act in aid of the judicial authority. So Taney raises, well, a very clear constitutional argument, to be sure, but he's also emphasizing the role of the judiciary in the legal system, if you want to think about it like that. And Taney says, as this case comes before me, I understand that the president not only claims the right to suspend the writ of habeas corpus himself, at his discretion, but to delegate that power to a military officer and to leave it to him to determine whether he will or will not obey judicial process. No official notice has been given to the courts of justice or to the public that the president claimed this power. Now, that's important. You know, Taney is saying Lincoln is acting on his own, and he has not told officially the judiciary or the American public what he's doing. No official notice has been given, and I certainly listened to it with some surprise, for I had supposed it to be one of those points of constitutional law upon which there is no difference of opinion, and that it was admitted on all hands that the privilege of the writ cannot be suspended except by act of Congress. So Taney is getting somewhat incredulous here. As he says, I thought it was a given. I thought we all agreed on this point that only Congress can suspend habeas corpus. Well, that is certainly the case. It's interesting here. I haven't highlighted it for you, but as you read the opinion, you come across his reference to the conspiracy of Aaron Burr. That's not something I know a lot about. It's an interesting historical episode in our nation's history, about Aaron Burr trying to foment a rebellion in the western part of the young United States after he has killed Alexander Hamilton in a duel. But I'd encourage you to read up on it if you're wondering what that reference is. That's partly it, I suppose. To get back to the case, Taney says the clause of the Constitution which authorizes the suspension of habeas corpus is in the 9th section of the first article. Article 1, Section 9. This article is devoted to the legislative department of the United States, Congress, and has not the slightest reference to the executive department. It doesn't talk about the presidency. And Taney goes on to say It was deemed necessary to guard certain great cardinal principles, especially those that affect the liberty of people and the rights and equality of the states. It was deemed necessary to guard those vital principles by denying to Congress in express terms any power over them. And so he's reminding us why we have Article 1, Section 9, the limits on the powers of Congress. Article 1, Section 9 contains very prominent fundamental principles that Congress cannot interfere with. Now, this is separate from the Bill of Rights, Amendments 1 through 10. This is in what we call the original Constitution, prior to the amendments, prior to the Bill of Rights, that the framers considered some principles of governance and liberty so vital that they prohibited Congress from interfering with them. And the writ of habeas corpus is one of those great principles of liberty that the framers sought to protect. And as Tawney puts it, the great importance which the framers of the Constitution attached to the privilege of the writ of habeas corpus to protect the liberty of the people is proved by the fact that its suspension, except in cases of invasion or rebellion, is first in the list of prohibited powers. And so what Tawney means there is the one great principle that the framers of the Constitution wanted to protect the most is the writ of habeas corpus. So much so, they put it at the very top of the limits on congressional power. It is true, as he says, that in the cases mentioned, Congress is of necessity the judge of whether public safety does or does not require the suspension of habeas corpus. And their judgment is conclusive. So Chief Justice Tawney is showing some deference to Congress. He's saying that when Congress suspends habeas corpus, its judgment is conclusive. It is the judge of whether public safety requires the suspension or not, and its judgment is conclusive. But the introduction of these words is a standing admonition, a warning to the legislative body of the danger of suspending it and of the extreme caution they should exercise. And what Tawney's recognizing, what the Chief Justice is recognizing, and what Congress certainly considers, is that suspending habeas corpus is something that is very, very dire and dangerous, as Tawney would put it. And Congress is and ought to be cautious about that. So, Tawney also mentions it's not just the writ of habeas corpus that we're talking about. It's also the Sixth Amendment, which Merriman did not even raise necessarily. That the Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime was committed. Tawney also mentions the Fifth Amendment further on, due process. And what he's saying is that even with the suspension of the writ of habeas corpus, even when the writ is suspended, and when the writ is suspended, what that means is the government can detain people without a judge ordering the person to be brought in and their detention justified. The writ of habeas corpus is suspended. It doesn't go away necessarily. It's only in abeyance. But those other great rights exist. The right to due process in the Fifth Amendment, the right to trial by jury in the Sixth Amendment, the right to a speedy trial by jury in the Sixth Amendment. And I think what Tawney is reminding us and reminding President Lincoln is even if habeas is suspended, these other great rights must still be protected. Now, skipping to the very end of the opinion, and You know, if you read it, and by the way, before we get there, just one other thing. Tawney gives us a really interesting history of the writ of habeas corpus, which I haven't highlighted for you, but he draws on Blackstone's commentaries on the common law from the mid-1700s, and Blackstone's commentaries were considered the Bible of the common law, at least in colonial America and in the young United States. He gives us a history of the writ of habeas corpus, why it is so important to us. But at the very end, you know, we can see Tawney's conclusion, right? Only Congress can suspend habeas corpus. Article 1, Section 9 makes that very, very clear. Congress can suspend it, no one else. And so Lincoln violated the Constitution. But Tawney's final order in the case is interesting. He does order Merryman to be freed in a sense, but he says, in such a case, I have exercised all the power which the Constitution and laws confirm upon me. The power has been resisted by a force too strong for me to overcome. You know, remember that General Cadwalader and the military ignored Tawney's summons. So Tawney says, it is possible that the officer who incurred this grave responsibility may have misunderstood his instructions from the president, exceeded the authority intended to be given him. Yeah, Chief Justice Tawney is saying, yes, maybe General Cadwalader made a mistake. I shall therefore order all the proceedings of this case with my opinion that President Lincoln violated the Constitution and Merryman must be set free. I shall order all the proceedings in this case with my opinion to be filed and recorded in the Circuit Court of the United States for Maryland, and direct the clerk to transmit a copy to the President of the United States. It will then remain for that high officer, in fulfillment of his constitutional obligation, to take care that the laws be faithfully executed, to determine what measures he will take to cause the civil process of the United States to be respected and enforced. So think about what the Chief Justice has done. He's given us this very ringing opinion about the Constitution, about Article 1, Section 9, the importance of habeas corpus, about Congress being the only institution with the power to suspend it, and then only in cases of invasion or rebellion or when the public safety requires it. And Tawney reminds us of the great rights that we have in the Fifth Amendment and the Sixth Amendment. And he reminds us about the importance of the judicial process for civilians accused of certain crimes. And he orders that Merryman be freed. But at the end of the day, Tawney says, I can do only so much, that there is a force too strong for me to overcome. So I will make sure that President Lincoln gets a copy of my opinion, and it will remain for him to fulfill his constitutional obligation. And so why does Chief Justice Tawney do that? It's hard to say. Perhaps he does not want to provoke a constitutional crisis with President Lincoln, where the Chief Justice of the United States orders the president to do something and the president refuses. But that has sort of happened here when you think about it. But it's probably the case that Tawney does not want to directly confront the president and create a constitutional crisis. The crisis would be where the president does not comply. And then in a situation like that, there is no answer in the Constitution as to what happens next. So Tawney probably does not want to provoke a constitutional crisis. He perhaps he doesn't want to hinder President Lincoln early in the Civil War. There might be something to that argument too. That as a federal judge and Chief Justice of the United States, he is somewhat reluctant to interfere with presidential power in a time of crisis. Now, it's hard to say because Taney doesn't really tell us what his motivations are. We get the sense that he's taking the easy way out, that he's not confronting the president like he should, but perhaps he is paying closer attention to the compelling politics brought about by the Civil War and the need for the executive branch to protect the Union at great cost. It's hard to say. Now, Lincoln does not order the release of Merryman. Lincoln does not take back or rescind his suspension of habeas corpus. There are a lot of other people like Marion who are caught up in the suspension, the president's suspension of habeas, and are arrested by the military and detained indefinitely. Merryman is actually charged with sedition, treason, being a Confederate sympathizer. He is formally charged. And interestingly, it is Chief Justice Taney who will be the trial judge in the circuit court in Maryland in Merryman's case. Taney postpones Merryman's trial once in 1863, partly because Taney does not want to engage in this criminal trial against a Confederate sympathizer at a very critical moment in the Civil War. Chief Justice Taney dies in 1864. In 1867, the federal prosecutor in Maryland finally drops the charges against Merryman, and he's let go. So he was effectively detained for about 6 years by the federal government. In 1863, Congress finally comes back into session. Well, summer of 1861, Congress finally comes back into session. And in early 1863, Congress suspends habeas corpus and sort of validates what President Lincoln had done up to that point. Now, there's one final thing I want to share with you here. So let me get into my desktop, and I apologize for this. When Lincoln brought Congress back into session, Lincoln made it quite clear about the steps that he had taken. I unfortunately can't find the file, so I apologize for that. But he gave a very important speech to Congress, July 1861, where he spells out to the members of Congress basically the things that he had done. He had suspended habeas corpus. He had reinforced Washington, D.C. He had blockaded southern ports. That blockade lasts, by the way, all to the end of the Civil War. He had ordered the mobilization of troops in the North. He had allocated a lot more money to the buildup of the Union Army, so on and so forth. But then, in talking to Congress, Lincoln says, he has this very famous phrase, "Must all the laws but one be followed as the Union collapses around us?" I'm paraphrasing that last bit. All the laws but one. And Lincoln was angry about Taney's order in Ex parte Merryman. The laws but one is the writ of habeas corpus, as Lincoln sees it. And the Chief Justice of the United States told him he had no authority to suspend habeas corpus. And so, as Lincoln saw it, we focused so much of attention on this one law, the writ of habeas corpus, so much so we ran the risk of all of our other laws and our Constitution collapsing around us. And what Lincoln meant was suspending habeas corpus by the president was a small price to pay, perhaps, for preserving the entire constitutional system. Worth thinking about. Anyway, we will, in the next lecture, go over the prize cases, the second important case coming out of the Civil War. All right? So, thank you very much.